This video is presented by Sadkin.com. Weingarten writes, an employee's rights during employer questioning. What are Weingarten rights? Employees are frequently questioned by their employers, for purposes of potential termination, reprimand, and even wage adjustment. Most employees are unaware that they have the right to union representation at such investigatory interviews. These rights are encompassed in the famous 1975 Supreme Court case National Labor Review Board v. Weingarten, Incorporated, now known as the Weingarten rights. Employees can use these tools to prevent management from coercing employees into confessions of misconduct. What is an investigatory interview? Weingarten rights apply only during investigatory interviews. An investigatory interview occurs when 1. Management questions an employee to obtain information, and 2. The employee has a reasonable belief that discipline or other adverse consequences may result. If an employee has a reasonable belief that discipline or other adverse consequences may result from what he or she says, the employee has the right to request union representation. Management is not required to inform the employee of his or her Weingarten rights. It is the employee's responsibility to know and request. That may seem counterintuitive that management does not have to inform an employee of his or her own rights, but the court felt that an employer should not be obligated to slow down the investigatory process. Employee rights. When the employee makes the request for a union representative to be present, management has 3 options. 1. Grant the request and delay questioning until the union representative arrives. 2. Deny the request and end the interview immediately. Or 3. Give the employee the choice of A. Having the interview without representation, or B. Ending the interview. If the employer denies the request for union representation and continues the meeting, the employee can refuse to answer questions. You can imagine the nervousness an employee must feel when entering such an intimidating environment. Steward rights. Employers sometimes assert that the only function of a steward at an investigatory interview is to observe the discussion, in other words, to be a silent witness. This is incorrect. The steward must be allowed to advise and assist the employee in presenting the facts. When the steward arrives at the meeting, the supervisor or manager must inform the steward of the subject matter of the interview, in other words, the type of misconduct being investigated. The steward must be allowed to have a private meeting with the employee before questioning begins. The steward can speak during the interview, but cannot insist that the interview be ended. The steward can object to a confusing question and can request that the question be clarified so that the employee understands what is being asked. The steward can advise the employee not to answer questions that are abusive, misleading, badgering, or harassing. When the questioning ends, the steward can provide information to justify the employee's conduct. Hopefully no one has to deal with difficult employees or employers. This video is presented by http://sadkin.com